everyone. Welcome to our webinar today. We're going to go ahead and get started. My name is Jean Chung, and I'm the Communications Manager at the Sentencing Project. Our webinar today is on realignment in California, and which the Economist has called one of the great experiments in American incarceration policy. The realignment policy was adopted in 2011 and has resulted in a large-scale shift of correctional resources and supervision from the state level to local counties. Today's webinar is hosted by the Sentencing Project in collaboration with the American Academy of Political and Social Science. Our panelists will give an overview of realignment in California and highlight key findings reported in the current issue of the Annals, The Great Experiment, Realigning Criminal Justice in California and Beyond. The American Academy of Political and Social Science has graciously made this issue available for complimentary access to everyone attending today's webinar for the entire month of March. So after the webinar, both the slides from the webinar as well as the recording will be available online, and we'll send the link with the realignment issue of the Annals, which will be good until March 31st. We'll also have a Q&A session after the presentation, and you can submit your questions throughout the webinar using the questions panel on your webinar menu. And our first speaker today will be Marc, the Executive Director of the Sentencing Project, who is one of the country's leading experts on sentencing policy, race, and the criminal justice system. He's directed programs on criminal justice policy reform for 30 years, and he will give a brief overview of realignment and its implications in the national context of decarceration. With that, I will give it over to Marc.
Thank you, Jean, and thanks to everyone for joining us today. This webinar is an outgrowth of a convening sponsored by the University of California at Irvine in 2014, at which a range of scholars were brought together to consider both the political history of realignment, the impact in a variety of ways, both within and outside the criminal justice system. And now we, as Jean has noted, we are delighted that the Annals has graciously published this wonderful collection of pieces, highlights of which we'll be talking about today. Let me just give a very brief overview of realignment, and then we'll get into the substance of the research. Realignment comes out as a result of a decision by the U.S. Supreme Court in 2011 relating to conditions of confinement in California prisons. In that decision, the court found that conditions of confinement were unconstitutional due to severe overcrowding in the prison system, which affected the quality of adequate health care and other services. The court required that the state reduce the prison population by 25%, more than 30,000 people, over the following 2 years. And so in response to that, the California legislature adopted the realignment policy in 2011. Next slide. Essentially, realignment readjusts the use of corrections resources and supervision and changes the nature of sentencing outcomes. So it limits state incarceration to people convicted of violent, serious, or sex offenses. People convicted of other offenses cannot now be held in California prisons, and with just some exceptions, persons who violate probation or parole supervision are generally not eligible to come back to state prison, but rather will be supervised locally. Next slide. The impact to date has been quite substantial in realignment. The state has met the Supreme Court order of reducing overcrowding to no more than 135% of capacity. There's also been a very substantial reduction in the number of people under parole supervision, a 2/3 reduction there, and not surprisingly, a significant increase in the number of people under local supervision, whether it's for an original sentence or through a violation of conditions of supervision. We know as well there's been significant statewide variation in how realignment has been put into practice. Realignment can result in increased jail populations, can result in increased numbers of people under supervision in the community. In general, more people are being supervised in the community under probation, but substantial numbers in some counties are being held in local jails. But overall, a very dramatic shift from statewide supervision to local supervision. Next slide. As Jean noted, realignment is described by some as a great experiment, and it is a great experiment in the sense that at this moment we have today where there's increasing discussion momentum for considering decarceration strategies. In practice, only a handful of states have achieved any substantial reduction in their prison populations. California's one of about 4 that have achieved more than a 20% reduction in their prison population over the last 10 or 15 years. So in that regard, it gives us a good case study of what the impact is of substantial reductions in prison populations. Many of the qualities of the realignment policy could certainly apply equally well to policies and practices in other states. So some of the issues we want to explore today from the scholars who have been engaged in research look at the impact alignment on crime rates overall in the states, the impact on recidivism of people going through the system since realignment, and what that shift in resources looks like going from the state to local corrections, what issues are raised by that, how did this come about in the first place. So we hope that while the findings are particular to California, policymakers, practitioners in other states certainly can benefit from what this experiment has looked like and certainly where it will be going in the years to come. Thank you. And Jean, you can take this now.
So I think I'm next. And what I'm going to talk about is the ways that the prisoners' rights bar, the advocacy community among lawyers in California, was able to get realignment accomplished, and how California is different from other states in the ecosystem that applies to the prisoners' rights bar. And maybe I'll say a couple of words about why that's a problem, both in California and elsewhere, and what the problems are. So let me start with the next slide. Oh, you know, I didn't mean to do these. Just go ahead all the way through it. There we go. So the background for all of this is the Prison Litigation Reform Act, which was a statute passed in 1996 as part of the Newt Gingrich contract with America. It was signed by President Clinton as a way of ending the government shutdown that year, and it came into effect nationwide. The PLRA doesn't exist on its own. There's a similar trend in case law separately from the statutory law. But together, what the two have done is two different ways that have been pressuring and shrinking prisoners' rights litigation. And so I divide those in my head into two different ideas. One is friction and the other is starvation. By friction, what I mean is that the cases are, as it says on this slide, harder to bring, win, and maintain. So everything is harder for prisoners' rights advocates. That doesn't mean it's impossible. It's just everything is slowed, made more expensive, made more difficult, and that's come at a very great that's caused a very great shrinkage of the amount of litigation and the effects of that litigation. In addition, the starvation effect is that both the PLRA and a variety of similar case law moves have made the prisoners' rights practice much more difficult to sustain monetarily. Okay, so go to the next slide. How has this all happened? The answer is prisoners, this is a variety of methods, but prisoners are now required to use prison grievance systems prior to seeking to vindicate their federal rights in court, and that includes if they have lawyers. This doesn't sound like it would be all that onerous, but in fact it's a very large effect because it's very difficult to properly use prison grievance systems, which have every incentive to make them, prisons have every incentive to make those grievance systems complex and onerous, because if you mess up and fail to cross a T or dot an I, you can never bring a case in federal court. And so we've begun to see very difficult, not just begun to see, we have seen over the past decades, very difficult grievance systems. In addition, the other effects need less explanation. Filing fees have gone up, attorney's fees have gone down, damages are less available. Settlements in injunctive cases, in cases about court orders, are constrained in a way that it used to be only litigated judgments, only contested judgments were constrained. They have been narrowed in their permissible scope. Those cases, I'm going to skip to the last bullet, those injunctions last less time and have to be defended more often. And finally, prison and jail population caps, like the ones that we saw in, that we have seen in Plata that prompted realignment, are much harder to come by. So, and I'll talk about that in realignment in a second. So if we skip to the next slide, what we can see is a nationwide effect. It's very extreme. It used to be that federal district courts cases that had orders governing prison conditions, this is in the first row of this table, those orders used to govern conditions in some way, shape, or form in about half of the nation's prisoners. But these days, those orders seem to cover much closer to a fifth of the nation's prisoners, jail and prison alike. So that's a huge shrinkage. Likewise, just in terms of the number of cases filed, these are mostly damage actions rather than court order injunctive cases. But for damage actions, in 1994, those were filed at a rate of about 25 per 1,000 inmates nationwide, though with a lot of variation across states. And now the nationwide rate is about 10 per 1,000 inmates. So again, more than a half shrinkage, similar in scope to the shrinkage in court orders. The litigations succeed less often, so it's not as if what's been happening has been that the bad cases are weeded out and what we're left with is the good cases that are fair. In fact, because the cases are so much harder to bring, they succeed less often, and that makes sense. So the most broad definition of litigation success, which is to say when a case either settles or it leads to damages or it's voluntarily withdrawn, which might be a settlement, although it's very hard to tell in the data. We used to see that in about 16% of federal prisoner cases, and now it's down to about 11%, so a pretty significant shrinkage. This is, of course, on the much smaller base. And so we're getting many fewer litigation successes. And in terms of attorney representation, the starvation effect has had a very extreme case as well, a very extreme effect as well, where it's gone from, you know, a good proportion of cases, 17%, down to a tiny proportion of cases, near only 5. So that's nationwide. If we look at the next slide, what I suggest in my piece that's in the Annals issue is that that doesn't mean that litigation is unimportant. Actually, it remains very important. It's just been shrunk in its effects. So we continue to see court order, injunctive remedies in cases about solitary confinement, prisoner sexual abuse, and a variety of other topics. There's just fewer of them, and they control what goes on at fewer prisons. Damage actions remain real, and prisoners do occasionally win compensation, but it's just a less significant effect. But if we think about what's going on in California, the story is quite different. So if we switch to the next slide, in California, there are court orders governing every prison in California because of Plata and Coleman, its companion case. And And in fact, there has not been a shrinkage in the proportion of litigation in California. The rate of filing of the damage actions remains about as it was in the 90s compared to the national 60% decline. Now, I will say California's rate is not high. California's rate is average now. It was very low in the 1990s, so you need to keep that in mind. So if we think about what's going on in California, and we switch to the next slide, I hesitate to disagree with Marc about anything, but Marc said realignment was in response to the Supreme Court decision in Plata, and that's true. Realignment was signed into law in June of 2011. The court decision at the Supreme Court was just a couple days before that. But what realignment came from was a much more massive, not a single case, but a much more massive and very long-term set of litigation strategies by a pretty large number of lawyers. Realignment, the Plata case joined up Coleman and Plata, two cases, one about medical care, the other about mental health care. Coleman was started in 1990, Plata in 2001. They had gone on a very long time with their lawyers trying very hard to remedy what was going on as far as unconstitutional conditions in California. The lawyers finally got up to a population reduction strategy in 2008. They had a trial on a population reduction strategy and won that trial and got an order in 2010 in the district court. I have marked on this chart a tentative ruling where the district court said, I'm intending to do a population reduction order in February. And that is what you can see in the prison population, which is the top line on this chart, is where the drop begins to happen. Because the state began to respond to this pressure from the district court, which it appealed. It appealed to the Supreme Court, and the Supreme Court affirmed what the district court had done. But the pressure began in the district court, and it began with a very complicated and full set of trial strategies by a lot of civil rights lawyers. And so what we got from that, as Marc said, was realignment and this very, very steep population decline. Next slide, please. So if we think about whether Plata and Coleman were alone, the answer is no, they are not. This figure sketches each of the major California prisoner court order cases, starting in 1965 and going to present, and the dark gray part of the bar is when the order actually governs prison conditions, and I put in the PLRA. What you can see is there are a lot of cases in California that have that govern prison conditions in an injunctive way. It's not just Plata and Coleman, it's a whole variety of these cases, and if you look at each of them, they each govern a different aspect. So there's one about dental care, and there's one about solitary confinement, and there's one about mental health care, and there's one about parole, and so on. This is an entire complex set of pressures coming from prisoners' rights lawyers who are litigating a lot of cases in the Supreme Court. It's not just one case, but the entirety of it together. And so the way that we've gotten this decarcerative move is as a result of this entire ecosystem, plus litigation in the jails, which has been part of the reason why when there's been devolvement to the jails, that the jails haven't just kind of grown their populations to absorb the new people, but have instead come up with, some of the jails have come up with strategies to get people out who don't need to be in jail. So how is it that California is different? If we go to the next slide, I sketch out in the piece a whole bunch of reasons why California is different. One more, advance a couple more if you can. I didn't mean to do this complicated thing with the slide. Another couple. There we go. Oop, back. Oh well. So if we look at it, the California bar is a very large bar, and it's a particular kind of bar. It includes a slight disproportion of big law firms and public interest lawyers who work on these cases, and a very disproportionate population of what are called private public interest lawyers, which is to say lawyers who do work that is similar to the work done by the public interest bar, but who do it and earn a profit doing it. Not necessarily a profit like they might earn doing regular non-public interest work, but nonetheless they are not funded by foundations or donations. They're funded by their legal work doing public interest work. And that's been a really important part of it. And now if we go to the next slide, there is, in addition, I think a really important effect of just how many cases were already in effect in 1995, 1996, when the PLRA passed, where the prior ecosystem, which did not put quite as much pressure on the bar, had produced a lot of litigation that needed to be continued to be handled. And so those cases were handled. And so at the moment when prison litigation looked kind of like the least good bet in terms of being able to make a living or even pay for itself, those cases had some staying power. People needed to finish them up. And that, I think, was a very important feature. And then on the next slide, a couple of other factors. The Ninth Circuit cannot be, it can't be understated just how important it is that California is in a circuit where courts of appeals do not erase victories in the district courts. It's a fairly left circuit. The fee expertise from the private public interest bar is a really important feature as well, where the lawyers in question really had already become very expert and got to be even more expert in actually litigating fees and how that worked, which was expertise that kind of wasn't present in other bars. And so the result of that is that all those cases that were in the pipeline kind of led one to the next, where the expertise and reputation of the lawyers involved kept them in the prison litigation business, and where they got exposed to facts that were able to be then used in the next case. So, so what we've seen is this ongoing existence of a prisoner's rights bar in California, where it has not been decimated by the Prison Litigation Reform Act and the generally unhospitable environment of the federal courts, but has remained an important influence on what goes on in California. I suggest in the paper, and this is my last slide, that it's not so clear that this is sustainable, even in California. If we can go to the next slide. The reason being that even in California, the Prison Litigation Reform Act and its provisions that govern the relitigation of existing decrees has pressured litigants into, instead of having decrees that last a very long time, into having very definite and very short sunset periods in their decrees. And that's a really big change, and one that we haven't quite seen ramify yet, but we're going to. The other thing is that as there's been some devolution of population from the prisons to the jails and jail litigation becomes more important, but jail litigation is hard. It's hard to monitor what goes on in jails, and they are smaller, less able to, they're just less able to sustain the kind of lawyers' infrastructure. And I think that's really going to be a challenge. So we'll have to see, as the various lawyers in California who have actually accomplished a good deal in terms of the prisoners' rights enforcement and who have kind of pushed the state into this decarcerative experiment, whether they are able to maintain their fiscal, sustainability. It would. My position, my perspective on this is that it's very important that they do, and that it would be better if in other states we had a more robust prisoners' rights bar as well, that having a prisoners' rights bar is a really important part of continuing to have some kind of accountability for what goes on in prison and some kind of incentive structure that helps encourage appropriate conditions of confinement. So, but we'll have to see what happens in California.
Thank you so much, Margo. That was Margo Schlanger. Professor Schlanger is a professor of law at the University of Michigan, where she teaches torts, constitutional law, and classes relating to civil rights, prisons, and policing. Before entering law teaching, she earned her JD from Yale in 1993, clerked for Justice Ruth Bader Ginsburg, and worked as a trial attorney in the U.S. Department of Justice, Civil Rights Division, to remedy civil rights abuses by prison and police departments. Now, our next panelist is Ryken Grattet, a research fellow at the Public Policy Institute of California and a professor of sociology at the University of California, Davis. He previously served as Assistant Secretary of Research in the California Department of Corrections and Rehabilitation. His current work focuses on California correctional policy at the state and local levels. And with that, I'll give it over to Ryken.
Great, thank you. And thank you to the Sentencing Project and to the Annals and UCI and National Science Foundation for supporting this this series of events and projects. I'm looking forward to your questions. My charge in this is to summarize a little bit about what we have learned about realignment and recidivism, and I just want to highlight a couple of things to start that Marc brought up. Really, realignment gave a lot of new responsibilities to counties. It provided them with some resources, some funding, and one of the principal overarching goals was to reduce recidivism, to do better in terms of recidivism outcomes than the state had historically done. The realignment literature legislation is sort of littered with references to evidence-based practices and assessments and being data-driven, and you know, recidivism becomes a very important measure of the system performance as a result of that. In exchange for the resources that the state provided, the counties were required to submit implementation plans telling the state how they were going to spend the money, and those realignment implementation plans turn out to be useful documents for trying to understand how local governments are sort of using resources to try and manage the new responsibilities. And really, sort of the overarching question that we focused on in the research community is really, can the counties actually do better in terms of recidivism? So next slide. Next slide. Yep. Just a little bit of background on sort of where the source of the research really starts here is in terms of data provided by CDCR, California Department of Corrections and Rehabilitation, that relates just to the prison releases part of the realigned population. It leaves out a segment that I can talk about in the discussion, but it gives us a pretty good sense of those individuals who used to be the responsibility of the state and are now the responsibility of the county. One of the things you have to do is make some adjustments for differences in the composition of the populations. We can talk about the composition of the post-realignment prison release cohorts are a little bit different than the ones that were released pre-realignment. And really, you want to, in research, make apples-to-apples comparisons. You want to make adjustments for those differences. And we also want to kind of contrast individuals who were released prior to realignment and observed their recidivism outcomes in a period prior to realignment with those released entirely after realignment. These are sort of the pure cases, the pure cohorts that we can compare in the research, and we can look at recidivism windows that vary from 6 months to a year, and so some of the results I'm going to talk about differ in terms of what the observation period is. So next slide. So let me sort of jump into the first recidivism outcome of interest. And so basically the top line here really kind of tells the big story, which is that there was a decrease post-realignment by about 2 percentage points in all arrests, but we can see there was actually an increase in felony arrests. And so I think we can kind of conclude that the decreases we observe overall in arrests are driven by decreases in misdemeanor arrests and supervision arrests. And I want to emphasize something that Marc said, which is that one of the things the realignment legislation did was it sort of cut off the possibility that individuals who are arrested for supervision violations could be returned to prison custody through the revocation process. And so in all recidivism research, there's always a question of whether or not The changes that you observe in recidivism outcomes is due to changes in individual offending patterns of behavior or due to how the system responds to those individuals. And cutting off the avenue of returning people through the revocation process appears to have led to pretty substantial declines in supervision arrests and a somewhat of a shift to felony arrests. Now, we could also interpret this in terms of changes in the severity of the punishments, sort of lessening the deterrent value and in some sense eliciting more serious offending, and therefore you see more felony arrests and less of the other kinds of things. And then the last line is also very informative, which is that it was a pretty substantial increase in the percentage of individuals who had multiple arrests. And that's likely due to the fact that we think that there was a decrease in the amount of time in custody for individuals after realignment. There was essentially people were more on the street in the post-realignment period, and therefore those who were engaging in offending behavior were more likely to rack up multiple arrests. So next slide. So the story in relation to convictions is a little bit more consistent and easier to narrate. We see an increase across the board in convictions. The percentage of all convictions increased by 2.1%. And again, this is potentially due to the reliance on the formal criminal prosecution process instead of relying quite so heavily on the revocation process to return people to custody. And then I think the last bar on this also quite interesting. We see an increase in conviction conditional on arrest. It means a greater percentage of arrests resulted in convictions rather than some other kinds of actions. Again, suggesting that the system is responding differently in the post-realignment period. Next slide. So the last piece of the story about the overarching patterns as it relates to prison, and you can see this here. I want to have you focus on just the line relating to return to prison, which on my screen is brown, and the substantial decrease in returns to prison, which were a direct result of the policy change that meant that revocations had to be spent in local custody. What we see is a pretty dramatic decline immediately after realignment, but a sort of creeping up in the months after that. Next slide. So the story also of realignment is also a story of county variation, and some of the work that we've done is really tried to understand what accounts for different degrees of change in recidivism patterns across different counties. And this chart gives you a little sense that in some counties recidivism measures increase quite a bit. Ventura, there's felony arrest rates increased 33%, and then Mendocino's decrease went the other direction, and of course most of the counties were in between. There's many more counties than just the ones listed here, but this gives you a sense of the variation. So lots of variation across counties. Next slide. And the same is really true in convictions as well. Some counties experiencing increases in conviction rates, and others experiencing decreases. So next slide. So back to the implementation plans that I mentioned at the outset, which is basically a kind of a glimpse into how counties thought policy-wise, strategically, in terms of the management of these new populations of offenders. And because they had to report back to the state, we could look at those plans and try and identify differences in policy strategy in order to try and determine whether or not those policy strategies are linked to the differences we see across the counties in those recidivism outcomes I just showed you. And what we found is that there was quite a bit of variation, and some counties could be kind of grouped into a a cluster of counties that really were emphasizing reentry, and another group really tended to sort of focus more on providing resources to enhance enforcement. And so, for example, counties that were reentry focused tended to spend a much greater share of the budget that they were given, or the funds that they were given, to programs and services. Enforcement-focused counties tended to spend more money on jails and law enforcement, and tended to rely on a narrower range of reentry services. So these represent sort of two different clusters of counties. Next slide. And what we wanted to see is whether or not those policy strategies were associated with any differences in recidivism patterns. And what we see is pretty much across the board, the different kinds of recidivism measures, there were reductions in recidivism were actually greater in the counties that emphasized reentry services. Now, this is really fairly preliminary. It's an early period after realignment. It's also really focused on policy strategy. We don't really know at this early point exactly what counties are putting into the field in terms of programs and services and strategies, but it provides a kind of initial kind of clue or glimpse that focusing on reentry services might yield better outcomes in terms of recidivism than an enforcement-oriented strategy. Next slide. So this is just a summary slide that kind of hits the major points that we've kind of discussed in the research thus far. Like a lot of recidivism research, what's the impact of realignment on recidivism? It kind of depends on the measure, which population you're looking at, and even which location in the state you're looking at. We have seen a pretty dramatic drop in returns to prison, but it seems to be creeping up a little bit. Big unknown here is what the impact on jail custody is in terms of recidivism. Are those offenders that used to go into state prison just going into state jail or county jails now? Well, hopefully we'll know some answers to that in the coming year or so, but at this point we don't know. Arrests, we see some modest decrease. We see kind of a shift from felonies away from supervision violations, and we see kind of multiple arrests increasing. Convictions increasing, especially for felonies, and then I think really importantly, convictions conditional on arrests are increasing. This is the greater likelihood of an individual who's arrested to to actually be subject to a conviction rather than a revocation. And then really the last point is really about kind of considerable local variation in how implementation's unfolding, with counties that really look to spend their money on enforcement tending to perform a little bit worse than those that focus on reentry services. Next slide. So a number of additional questions that we can pose here. I think I'll just sort of leave these on the table here, and because I want to make sure we have time for some of the other speakers and have time for questions. So I'll just stop there.
Thank you, Ryken. Our next speaker is Magnus Lofstrom, a senior research fellow at the Public Policy Institute of California. His areas of expertise include public safety, immigration, entrepreneurship, and education. His recent work examines crime trends in California, public safety realignment and recidivism, and California's jail capacity and construction needs. Prior to joining PPIC, he was an assistant professor of economics at the University of Texas at Dallas. He received his PhD in economics from the University of California, San Diego. And with that, I'll give it over to Magnus.
Great, thanks, Jean. Okay, so let me just point out first here that the paper that I'll be talking about here, that was part of the special issue, is co-authored with Steve Raphael at UC Berkeley. And there's no need to kind of get into the changes that were brought about, realignment. We've heard about them here. But what we're going to be focusing on here is how it affected the incarceration, prison incarceration in California, and whether it had an impact on crime. So let me point out the two key features that affected overcrowding and prison incarceration in California. And Ryken talked about this. One of the key features that had contributed to overcrowding in our state prisons here in California. And with realignment, you can no longer send back parole violators to state prison. They're now locally sanctioned in the county. The other important feature was that most low-level felons now go to county jails instead of state prison. That's assuming that they don't have a record of serious crimes. And then, importantly, when we're thinking about realignment in terms of its usefulness as a policy evaluation, and what kind of lessons we can learn for the rest of the country, I think it's really important to keep in mind that this was really a very quick, and it really was a mostly unanticipated enactment. And in fact, this whole process from proposal to implementation only took 9 months in California. It went from governor's proposal in January of 2011, and then it was implemented as soon as October 1st of 2011. Next slide, please. And what we see is that it did have a very quick and substantial, led to quick and substantial decline in our prison population. And what I'm showing you here are the weekly admissions and releases from our state prisons going back to the year right before realignment to May of 2013. And what you see there is that admissions and releases, they were pretty much, they fluctuate, but they were hovering around 2,300 per week. And what it tells us then is that the prison population was relatively stable in that year right before realignment. It was coming down a little bit. But then we see, with the implementation of realignment, we see a very noticeable drop in the weekly admissions. And this is really driven by, primarily by the inability of returning parole violators to state prison. So as soon as we get to that point, we see that it quickly goes down to about 500-600. When those weekly admissions are lower than the releases, that means we're drawing down the prison population. And we see also that the releases, the weekly releases start to come down quite noticeably with realignment, but not as quickly. We see that after roughly 1 year, they come back to a level where they're roughly the same. And it means that the prison population stabilized. And what we had in that 1 year, the prison population dropped by about 27,000. So very noticeable decline. Next slide, please. But as been also pointed out here, both by Marc and Ryken in particular, realignment wasn't something that was felt equally across the state or was implemented in the same ways. And we see these big differences across counties. So if we think about what realignment did in terms of prison incarceration rates and reliance, we can see that dose, if you want to think of it as a dose, it varies quite dramatically across counties in California. And for example, the prison incarceration rate total statewide dropped in that first year from about 435 per 100,000 residents to about 360. So it dropped by about 75. But we see these big differences across the counties. And we see in some counties it dropped by about 234, whereas in the ones with the smallest decline, it was a double digit, about 17 or 18. So there were really big differences across the counties. And when we think about this from the concerns about something like realignment, we can put this in the context of how does it affect and put additional offenders on the street. So what this is telling us, that it had a big differential impact across counties. And the counties such as Kings and Shasta saw a relatively large number of additional offenders on the street as a result of realignment, whereas Contra Costa and Marin saw relatively few. And then there is an important point then, well, why do we see these big differences? And as this table suggests, it's really the big changes, the biggest changes are really, it took place in those counties that had a high reliance on our state prison system in California, like Kings and Shasta. Kings had the highest prison incarceration rate in the state with over 1,000. And then the lowest ones were seen in Contra Costa and Marin, San Francisco, for example. Next slide, please. So the research question we're really trying to answer here in this paper is really, with this very noticeable and substantial changes in incarceration, did realignment have any impact on crime? And we really want to try to identify what the incarceration effect on crime is. And our strategy is kind of a twofold here. First, we're going to take a look at it from the county level, and we want to take advantage of this cross-county heterogeneity in the impact of the reform on those county-specific incarceration rates, what we just saw in the previous table. But we also want to take a step back and look at this from the state perspective and compare California to other states to see if there are any deviations and noticeable changes in our crime rate trends post-realignment, and whether we can tie that in that case to this historic reform. And then with that information in mind, then we were thinking that, well, let's put this in a cost-benefit perspective and see if we can answer the question of to what extent incarceration is cost-effective crime-preventive strategy. Next slide, please. Okay, so you can just push through this and get them all there, so we don't have to wait. The first thing is then we really view realignment here. We're going to treat it as a natural experiment, or as a quasi-experiment here, where to some extent realignment then represents an approximation of random changes to our prison incarceration rates or offenders on the street, and how that's going to vary across the state in the various counties. And we focus on the role of the changes in the prison incarceration rates. And that's where we deem this to be an exogenous change. We're going to take advantage of that, and then also taking advantage of the fact that it varied quite dramatically across the counties, and it also changed over time. So in the counties, it's going to differ. They're going to differ in terms of how many offenders you're going to see on the street. And then since the implementation, that number, even within the county, is going to change. And we're going to take advantage of that to try to really isolate the effect of the incarceration effect on crime. Of course, there are, as Margo pointed out, there were some changes that were taking place before realignment as well. So there are some trends that are already built into data. We would have seen some of these changes no matter what. There's seasonality that differs across the states, across the state and various counties. So we're going to purge the data of those factors. And then importantly, counties are going to respond to this differently, as Ryken pointed out. And in one important context that is very relevant here is also that how they go to incarcerate these offenders and inmates in the county jails is going to differ. So we're also going to adjust for those county jail incarceration responses. And then there are, of course, a number of factors we don't have data on that also could have an impact on this kind of analysis. We will also use something called the county fixed effects approach here to really adjust for unobservable county-level factors that don't change over time. So think of things that were already in place, the capacity constraints that the counties face, maybe their overall ability or approach to dealing with these criminal justice situations. And what it comes down to is really a regression-adjusted comparison of these county-level changes in prison incarceration rates against those county-level changes in the crime rates. Next slide, please. So we can we tried various specifications, tried different ways to estimate the effects here on crime rates, but we can really summarize this in one figure here, and that's the figure that we have in front of us right now. That really relies on our preferred specification to dealing with this empirical issue. And the little dots that you see there, they represent our estimated impact of one fewer offender incarcerated as a result of realignment on the number of crimes per year. So that's what those little dots represent. And then you see these arrows. The arrows really represent the precision of the estimates, or put differently, they're really the confidence interval. They're the 95% confidence interval. And then to determine whether an estimate is statistically significant, we can visually see that because those are only the ones where none of those arrows cross the horizontal 0 line. And as you can see here, there's only one crime rate that we can say is statistically significant increased as a result of realignment, and that's motor vehicle theft. And so we estimate that to have gone up by about 1.2 auto theft per offender who was not incarcerated as a result of realignment. For all other types of crime, we see we don't find any evidence that it was a statistically significant effect based on realignment. And importantly, when we look at the violent crime rate, we can see that those estimates they're really right around the 0 line, and they're relatively precisely estimated zeros. That gives us some confidence that there really isn't any convincing evidence that realignment pushed up violent crime rates in California. Next slide, please. So we also took this step back and said, well, let's take a look at it from a broader perspective, not just focusing on the prison incarceration rate, but let's also see what we see if we compare California to other states. We're going to use state-level data as well. And what we want to do here is to generate estimates of what the crime rate trends would have been if realignment had not been implemented. So that's our approach here. Really what we want to come up with here is a counterfactual for California. And the way that we do that here is using a data-driven technique to identify suitable combinations of states that had very similar crime rate trends to California's before California implemented realignment. And then we can look for whether our crime rate trends after realignment, if they deviate and they differ from those of the comparison states, under the assumption that that we were able to find states with similar crime rate trends, and then that they hadn't imposed these kind of changes. And of course, no other state imposed changes that were really close to the magnitude of what California did. So that's what we did. So let's take a look at those results in the next slide, starting with the violent crime rate. So the first thing here, the orange line then is California's violent crime rate trend going back to 2000, and then the comparison states that our method is identifying. The first part is to see that prior to realignment, what we see is that this method actually identifies a set of states and have very similar violent crime rate trends to California. And then importantly, we don't see any evidence that our violent crime rate trends start to deviate from those comparison states post-realignment. And also when we break this down by the types of violent crimes that the broader violent crime rate represents, that's murder, rape, aggravated assault, and robbery, same result. They don't find any evidence that California's crime rate trends post-realignment deviated from the identified comparison states. Next slide, please. If we take a look at the property crime rate trend, again, California in this orange line here, we see that this method does a very good job in identifying comparison states that have very similar crime rate trends to California prior to realignment. But then we see in 2011, so this is when realignment was first implemented in October, we see a little bit of a higher crime rate in California, and then it becomes noticeable in 2012, and it stays, that gap that opened up in 2012 stays the same in 2013. And again, if we break this down by larceny, theft, burglary, and auto theft, the two components, the three types of crimes that makes up the property crime from the UCR, we see that this is entirely driven by auto theft. Next slide, please. All right, so this is my last one. So let me just summarize here. What we do find is, of course, has been pointed out here, is that this historic reform noticeably and significantly reduced California's reliance on incarceration. And importantly, we did so without any evidence of an impact on violent crime rates. We do see that there is a modest increase in property crime, and that's driven entirely by an increase in motor vehicle theft. So just put some numbers on that. We estimate that it increased the auto theft rate by about 70 per 100,000 residents. That's roughly an increase of about 17%, 17% as a result. And another way to look at this is then how, in terms of the prison years served, and we estimate that an additional prison year served prevents roughly 1.2 auto thefts at the incarceration reliance of California prior to realignment. So what these results tell us is that, well, incarceration does prevent some crime, but at those rates that we were at in California prior to realignment, that we're pretty much in the middle of the pack in the U.S., its effect is very limited. And then if we use these results to put them in a cost-benefit perspective, we see that an additional dollar spent on incarceration, it gives us only about 23 cents in terms of crime savings. And just to compare that to one additional crime preventive strategy, and that would be to spend our resources towards hiring more cops. We see that using research by Chapman and McCrary, we see that additional dollar spent on policing yields about $1.60 crime savings. So I think, taking a step back, it's what does this tell us? Well, it doesn't say that, okay, all we should do then is switch our funds and funding towards policing, but what we need to do is certainly look for alternative cost-effective crime preventive strategies. And that's it.
Thank you, Magnus. At this time, we are going to open it up for Q&A. So all of our panelists today will be unmuted. So you can jump in at any point. We already have some questions that have come in while everyone was speaking, but if you have not yet submitted your question, you can do so online in the questions panel on your webinar menu. Or if you are just calling in and aren't logged in online, you can email them to advocacy@sentencingproject.org. So I'd like to go ahead and start with a question that was sent in online. And the question is, has there been any evaluation of the effects on realigned people of being in the more restrictive jail conditions compared to their being in the generally relatively less physically restrictive conditions of prison? Is there anyone who would like to take that on?
This is Ryken. I don't think anyone has done that research yet.
This is Margo, and I agree with that. I would say that question is premised on something that I believe to be true, but it's not entirely clear, and it's bound to be true in part and not in part, which is the assumption is that the decarceration from the prison system has led to people being in jail, and then we've then had other people who aren't in jail. And that's partially true, it seems to me, without a doubt, but I don't know how true it is. So some of the people who realignment has affected are just not anywhere as a result of that, and I think that's worth pointing out.
Okay, thank you. Another question we've gotten is, how much of the felony arrest increase following realignment was due to drug possession arrests? What happens to all arrest or recidivism figures when we shake out drug possession?
That's a good question. The data that we had did not allow us to disaggregate by type of that degree of detail. But drug possession arrests are a large portion of the criminal justice population entries into jail as a whole. So it's likely that a good portion of them are, in fact, those types of offenses.
Okay. We have received a few questions about the impact of realignment on family visiting rates. So essentially the question is, have you looked at how visiting rates have changed as a result of realignment, since there's research that there's an association between improved institutional adjustment and or reduced recidivism among incarcerated individuals who receive visits or maintain connections with their families? Is there anyone who would like to take that on?
Well, I certainly don't have an answer to that question, but again, I think we have to think about these populations pretty carefully. So if the question is, has anybody looked at what's going on in the prisons as far as visitation rates, I'm not aware of anybody doing that. In the jails where some people are being incarcerated. You know, visitation to jails is generally easier than to prisons. On the other hand, some jails are shifting to video visits rather than in-person visits, and so that gets a little bit complicated. And some of the folks whom realignment has affected aren't in prison at all any longer, or jail.
Okay, that's a great point. Here's another question. Has there been a significant change in the fines and fees that are imposed on individuals who are no longer incarcerated for lower level offenses?
Is the question regarding realignment specifically?
Yes, I think as individuals who are no longer incarcerated as a result of realignment.
Well, realignment didn't bring about those kind of changes. Whether we've seen counties and cities making changes to that, I don't know if anyone has looked at that and if we've seen those kind of changes.
Okay.
I think it's important to say that realignment really changed the location of where someone would serve their sentence, rather than really changing the specific types of sentences. The sort of the elephant in the room here, I guess, is that California also passed a proposition in 2014, which actually did change a bunch of lower level offenses to be misdemeanors or exclusively misdemeanors. And I'm not aware that that there was specifically a change in relation to converting some things which had been jail or prison sentences are now fines. Instead, I don't think that was part of the legislation.
It might be worth noting that to the extent that probation terms have been shortened, and I don't actually know if California probationers pay, and parole terms too, I don't know if probationers or parolees pay fees for that, but if the terms have been shortened, then they would be paying, less fees because they'd be out from under quicker.
Okay. I'm glad that you brought up the probation terms being shorter, because one of the questions we received was, do you have any sense of how or whether the probation supervision that realigned people are receiving differs from the parole supervision they would have received pre-alignment?
Well, there are probably more similarities than differences. Both have kind of comparable standards of intensity. They try and distribute supervision to the people who pose the greatest risk. They have an array, but probably an insufficient amount of services that they can refer folks to. Part of the idea of realignment was to essentially fund county probation departments to cultivate services for people under their supervision. So in some ways, realignment may have enabled some counties to develop more options for services to aid reentry than they had previously. But CDCR, the state parole system, has day reporting centers and makes other kinds of service referrals and so forth. So probably more similar than different is the.
Okay, thank you. And you had also mentioned right before this Prop 47, and we had a question about that, which was, do the presenters have any thoughts on how Prop 47 might have impacted the trends that you discussed today, since the research that you discussed was pre-Prop 47?
This is Magnus. If we take a look at crime rates in California, we are limited to how much data post Prop 47 are available at this point. Prop 47 was passed in November of 2014. So the 2014 numbers that are out and available right now, you can't separate out exactly those months. So it's based on that, it's difficult to say. We looked at preliminary FBI UCR numbers that are limited to cities with 100,000 or more residents. And we did see, in that first half of 2015, we did see noticeable increases in both violent and property crime rates in California. When we looked at violent crime rates in particular, that seemed to be part of a broader increase that has been reported in a number of other larger cities across the country. The property crime rates stood out a little bit more in California than in the rest of the country. Most cities saw increases in both of these types of crime. But I think, you know, it's important to point out these are just for this first 6 months of 2015, limited to those larger cities. And you know, as we know, if you look at crime rates and their trends, you know that they fluctuate quite a bit. So I think it is too early, definitely too early at this point to say that that's driven by Prop 47. But it does quite clearly point towards the need to continue to monitor and have efforts in place to understand what is behind the changes that we are seeing in California.
Okay, thank you. Here's a question about Pell Grants, which says that in 1994, when Pell Grants were removed from prisons, they were not removed for people incarcerated in jails. So do you know if there's been any use of or increased use of Pell Grants for those serving sentences in jail? And perhaps this could relate to other benefits that they might have more access to in jail, for instance, like voting, or do you know if prisoners are voting in jail?
I don't think that, oh, go ahead.
No, go ahead. I was going to say I don't know.
Yeah, I don't think that the voting rights of prisoners turns on where they're doing their time. It rather turns on what they're doing their time for. So I don't think the voting question, I don't think there's been a change in that. As far as Pell Grants, I have to confess that I've never met anybody who's used a Pell Grant from a jail. It's hard to get your life organized enough in a jail to take advantage of that kind of program. That may be shifting as lengths of stay you know, accumulate in jail, and as people start to do greater lengths of stay in jail, perhaps there's actually some access to programs like that. But I have not ever met anybody who's done that.
Okay. And we have another question. Which reforms, or do you know of any reforms that counties have been able to institute, which could not have been instituted on the state level had there been no realignment?
You know, the key thing about county incarceration compared to state incarceration is that it has the potential to be closer to home. At least to me, that's a really important feature of it. So that people tend to do their prison time really far from their community, and they tend to do their jail time. This isn't always true, but much closer to their community. So so reentry feels pretty different, and integrative kinds of services feel pretty different when they're done in jails versus when they're done in prisons. And so I would suspect, although I don't have real data on this, that in the more reform-minded counties, they are taking advantage of that fact, and that actually is might actually be better for the prisoners in that way. There's a bunch of ways in which jails are worse for prisoners, but that might be one way in which jails are better.
I think one of the things that happened with realignment that probably would not have happened otherwise, that is that through these community correction plans that counties were required to draw up as a result of realignment, you increase communication across those local criminal justice agencies probation, talking to sheriffs to a greater extent, to health services, courts, and so forth. So you have increased cooperation and communication across those agencies as a result of realignment that I think most people here in California would say probably would not have taken place without realignment.
Great. Here's another question. How does the realignment apply to or impact the California inmates that are housed in private prisons in other states such as Arizona?
Well, it's given with the drawdown in the prison population, removing that pressure from our prison system. It has given the state an opportunity to actually reduce those out-of-state contract beds. And it's probably most noticeable, probably not as a result of realignment, but with Prop 47. And since with Prop 47, which further drew down the prison population, and that's really what took us down below the population target federal court issued, it's since then that we've seen a drop in these out-of-state contract beds by several thousand. So in that sense, realignment has led to some changes there.
Great. Our next question is, do you have a sense of what the political reactions have been to realignment and what the effect might be on future reforms?
Well, in the immediate aftermath of the passage and then the quick implementation, there was quite a bit of concern about the potential for a crime wave to be unleashed on the state. But as Magnus described in his research, that really hasn't materialized. So to some degree, those complaints have been muted. And then the story of sort of the opposition to realignment is very much a kind of regional one. There's a lot of variation across the county. There remain many sheriffs and police chiefs who are quite were quite opposed to both Prop 47 and realignment, and are quick to identify changes in the crime patterns in their communities to those reforms.
Okay, great. I think this question is for Ryken, but anyone else should also feel free to jump in as well. Are collateral consequences taken into consideration when realignment legislation is written?
That concept was not, I don't think, particularly prominent in the discussions about realignment. Maybe Margo or Magnus have a different perspective on that.
No, I interviewed a lot of people about the process that got from the court case to the political, solution, and I don't remember a single person mentioning collateral consequences even one time.
I mean, there's a lot of emphasis on trying to move. I mean, a big emphasis is on saving money. That's an important thing. But a lot of the impetus seemed to be to try and get better outcomes in terms of recidivism and embracing, kind of the mantra of evidence-based practices and, measuring performance and focusing policy around those things. That's pretty well woven into the legislation and the discussion about it.
I think there was also what Margo was referring to before. The proximity issue was definitely raised here, that by having inmates serving time in many cases closer to family, that can lead to improved outcomes, both maybe to some extent for the family and relatives and friends of these inmates as well.
Oh, I think there was definitely discussion about about sort of side benefits and advantages in terms of criminal justice outcomes. Not in terms of what's going to happen to licensing and voting rights and immigration consequences and all of those things. That is what I kind of understood might be meant by the phrase collateral consequences. All those civil disabilities that come with a criminal conviction. I don't think that entered into it.
Another stream of that literature has been on sort of the intergenerational impacts of incarceration on families and outcomes for the next generation, and that line of argument and line of research was not really referenced, to my knowledge, in the discussion about the legislation.
Okay, Marc, maybe you'd like to take this question. Which other states have achieved reductions in prison population? And where can I find the list of states that are similar to California's crime rate? And what types of policying has yielded some cost impacts?
Well, other states with substantial declines are New Jersey, New York, and Rhode Island. As I mentioned, each of those in the range of 25 to 30% over the last 10 or 15 years, and to some extent each state is unique in how they've achieved that. Generally some mix of decline in certain kinds of arrests, some changes in policy, whether it's sentencing or otherwise, change in practice, how things like drug diversion are used to try to target prison-bound defendants and make sure that true diversion is taking place. So there's much to learn from those other states. As we've looked at those states as well, looking at the impact on crime rates just in very broad terms statewide, these reductions have come about at a time when crime rates were declining nationally, and in virtually all categories of property or violent crime, the declines in these 4 states, including California, generally matched or exceeded the declines that we see nationally as well. So it's generally an encouraging development, I think, showing what's possible with decarceration. We didn't attempt to look at matching up California with others specifically in terms of their levels of crime or so, but we've seen a little bit of that in the webinar, and we would want to look at that more broadly, I think, for a variety of states going forward.
Great. Here's another question. Is there a list of which counties fall into the law enforcement focused versus reentry focused realignment plan clusters?
Yes, all that information is actually contained in the policy research, Public Policy Institute of California report that my colleague Mia Bird and I authored, and that can be found either by just contacting me or by visiting the PPIC website, which is ppic.org. And you'll find quite a bit of material relating to realignment on that website, including that.
Awesome. Could house arrest and home monitoring for low-level offenders save states money? Not all jails have the same minimum standards as state facilities. Do we know what's being done to monitor the treatment of people who are incarcerated in jails?
Well, there was kind of a cluster of questions there, but I'll take the electronic monitoring one. The realignment legislation encouraged the use of alternatives to incarceration, including electronic monitoring. I'm not aware of any specific research in California on the impacts of electronic monitoring, but there was a very well done study in Florida relatively recently that showed that it was an effective strategy for dealing with offenders and cheaper than custody.
On jail standards, there are California regulations that govern jail standards, which is not to say that all of the jails, are in compliance with that. Of course, that's true of prison standards too. And monitoring jails is very hard. I mean, they're very widely scattered. So California has lots of prisons, but it has even more jails. And so it's a complicated thing to do, which is one of the reasons why a devolution strategy, has disadvantages for prison conditions or for the conditions of confinement for California's prisoners, as well as advantages.
Great, thank you. And here's another question. Has prosecutor charging behavior changed in response to realignment? I've heard it said that making counties responsible for the cost of incarcerating low-level felons and violators could potentially make county DAs less aggressive.
I think it's one of the other important questions that really hasn't been looked at very closely yet. This is like so many other key questions. It comes back to difficulties with getting access and have the right kind of data to answer that. There have been stories about changes in terms of prosecutorial changes as a result of realignment here, but so far there hasn't been any thorough studies looking at it.
Okay. Our next question says, we keep hearing about this recent uptick in crime in California, yet no one has examined whether this trend can be attributed to realignment or Prop 47, isn't that right? In other words, at this point, these are just trends that could also be caused by multiple other factors like poverty, unemployment, housing, police community relations, gun availability, et cetera, et cetera.
Well, I think when it comes to realignment, Steve Raphael and I, and now there are other researchers as well that have looked at this specific issue. If the realignment caused any changes to crime rates in California, we did see increases in 2012 right after realignment in terms of both violent property crime rate. And as I mentioned during the webinar, we found no evidence that the violent crime rate increases that we saw that year had anything to do with realignment. We did find evidence that property crime rates went up a bit, modest increase, and that was driven entirely by an increase in auto theft as a result of realignment. With Prop 47, again, we're looking at that first year since Prop 47, and we are seeing increases based on those preliminary numbers that I mentioned earlier. But there has been, it's too early to tell Prop 47's role in that, if any. It is definitely a question that we'll be looking at. We do need, I think, we need more data, and we need slightly different data from what is currently available, but it is an important question to address for sure.
Great. Can you talk about movement towards justice reinvestment, especially with any money saved from realignment?
Well, I'm sure Ryken can probably say a little bit more about what's going on at the county. I can just mention in terms of how the state is spending money on corrections in general, we're actually not seeing decreases in our corrections expenditure in California as a result of realignment. We are actually at historic highs in terms of our corrections budget in California. So that hasn't necessarily materialized. I'm not sure if that's just a fair statement in the context of assessing realignment's impact, because I do think that it's important when we look at that particular issue, that with the situation, with the mandate to reduce the prison population, what were the options for California? One way to address the problem would be to build more prison or contract out more. That certainly would have led to higher expenditure on corrections. So even though we're spending more today than we did right around the time of realignment, if we would have taken a different approach to deal with the federal mandate, there is a good chance that we would have spent even more than we're seeing today.
Let me just add in terms of the National Justice Reinvestment initiatives led by Pew, the Pew is working with a couple of sites in California to implement their cost-benefit tools. So that's one thing to say. The other thing to say is that Prop 47 has a kind of reinvestment component to it, which is that the state's Department of Finance will calculate the savings that result from the reduction in custodial use, and that money will be returned to the counties and used, sort of earmarked for a range of different kinds of social programs, essentially. The other thing is that California in 2009 adopted a probation revocation policy that was sort of premised on a kind of reinvestment sort of logic, which is that they provided incentives to the counties to not return probation violators or send probation violators to prison, but if a county could reduce its probation revocation rate, the state would send money back to the county based on the savings to the state prison system. And that, in some ways, began to flood some resources into probation that then was expanded upon in Realignment.
Great. Based on your research, what do you see as recommendations for possible strategies for pushing towards reducing jail populations on a county level and reducing statewide spending as a result?
Well, that's also a huge a huge topic. You know, we've been really focused on trying to determine sort of the impacts of various kinds of policy changes on important outcomes. We've been a little bit less prescriptive on issues, but I think you could draw out the implication from a lot of the work that's been done on California that you know, kind of reducing our reliance on incarceration has had modest to small impacts on crime, and the story about recidivism is really not a story about a great transformation, even though we are relying less on custody. So I mean, if I step back from the research that has been done and sort of think about it in the broader context, it's really that we have scaled back our reliance on custody in the state, the most expensive resource, and it hasn't had huge impacts on negative impacts on the state in terms of public safety. So perhaps that's an invitation to proceed further along that path.
I'd like to add just one thing, which is that it's not based on the research done for this particular article, but California used to have a very high rate compared to the national average of pre-trial presence in the jails. So I don't, because it wasn't for this article, I don't have the numbers ready at hand, but it used to be very high. That number has slipped a little bit recently, which is great. I mean, using jails pre-trial, there's really just a massive overuse of pre-trial incarceration among people who do not pose a flight risk or a public safety risk. And I think that's very low-hanging fruit nationwide for decarceration, that it would be pretty easy to adjust practices to get people out of jail pre-trial when they do not pose a community safety risk. And that would both save money and it's very helpful for them in their lives to reduce the disruption to their ability to carry out their regular lives. From being in jail, there's evidence now that even 3 days in jail can be extraordinarily disruptive. People lose their jobs and they end up losing access to transportation, and they can lose their housing and so on. So I think everything we could do on that's very low-hanging fruit.
Okay. Wonderful. I think we have to wrap it up because we're out of time. I'm sorry if we didn't get to your questions, but you can feel free to email them in to advocacy@sentencingproject.org, and we'll try to connect you. The webinar slides, as well as a recording, will be available online, and the information on how to access them will be sent by email, along with a link giving you free access to the Annals issue on realignment for the month of March. So thank you so much to our wonderful panelists, and thank you to everyone who participated.